Today we're going to talk about motions to dismiss. These are motions brought by defendants at the commencement of an action to either defeat an entire complaint or a claim within a complaint. Motion to dismiss may also be brought as to a counterclaim or a cross-claim, both of which are very much the same as a complaint. And as I said, they are brought at the commencement of action before one answers the complaint. I want to be clear. You can answer the complaint as to those causes of action you're not seeking to dismiss by a motion to dismiss, and bring the motion to dismiss as to those specific claims you seek to dismiss, or you just simply bring the motion to dismiss. It's an option. So in a complaint, you tend to have multiple causes of action. So you have breach of contract, fraud, conversion, and negligence. You might say, well, on the fraud claim, I want to bring the motion to dismiss, so you bring it as to that claim, seeking the court to dismiss that claim, and the remaining claims go forward. At which time you file the motion to dismiss, you can either answer those claims, or you can wait until the court hears your motion to dismiss. But be careful, please look at local rules to make sure that the courts would not take issue with breaking it apart in that fashion. They're very difficult motions to win on the simple fact the court has to assume every fact pled in the complaint, or if it's a cross claim or a counterclaim, is true. So they look at the four corners of the complaint and assume every fact pled is true, and if every fact is true, then if that would support a claim, then that claim survives and it goes on. And the courts are very reluctant to dismiss a case right off the bat. It has to be very obvious. Some of the obvious reasons are statute of limitations. For example, let's say you asserted a breach of contract claim and said the contract was breached 8 years ago, and the statute of limitations is 6 years in the state in which you brought the claim. The court could go, well, it's barred by the statute of limitations. That's how you pled. That it was done 8 years ago, and the law says 6 years. That's 2 years past the statute of limitations, gone. Personal or jurisdiction over the subject matter. You bring a claim for patent infringement in state court. Well, federal courts have exclusive jurisdiction over patent claims. Even though everything you say about the patent could be true, and if assumed true, would support a claim for patent infringement, it cannot be maintained in a state court. So that would be dismissed. Jurisdictions amount. Certain states have district courts and superior courts, different levels of courts, and often the break point is $25,000. So if you pled that your damages, let's say, are more than $25,000, and you bring the case in the lower court, then it could get dismissed because your damages are too high, and vice versa. If it's below $25,000 and you pledge your damages below $25,000 and you bring in the higher court, the court could dismiss it on those grounds. Lack of standing. As a citizen, you can't bring a criminal matter. So if you asserted a criminal matter in your complaint, the courts could say, you don't have standing. Only the state could bring a criminal matter and dismiss it. So that's where it's obvious. And again, the court is supposed to look at what's only pled in the four corners. Courts at times can look at documents outside of the complaint. Normally that's a deed or the contract referenced in the complaint or attached complaint. They can look at that, and if it's on its face, it provides grounds for dismissal of the action, then the court can look at it. Let's say the parties to the contract are George and Henry, and you're Ralph, and you're bringing the lawsuit, and the court can go, well, you're not a party to the contract. It says who the parties are. On its face, you can't assert this claim because you're not a party to the contract. It would be an example of how the court could look at the contract. When when you file the motion, it essentially puts a stay on the action, meaning no discovery is to go forward until the motion to dismiss is resolved. So if the plaintiff has served you with interrogatories, document requests, deposition notice, admissions, those requests should be put on hold until the court decides whether or not the case goes forward in total or in part as to what claims it's granted or not. So the court can grant the motion to dismiss if it's brought on all claims to all claims or selective claims, or you can bring your motion to dismiss as to a few claims and not the rest of the claims. Ultimately, it can be a very effective tool on narrowing the scope of the case, which is always helpful in reducing costs and difficulties, and particularly as a defendant, the less claims against you, the less to deal with. I hope that was helpful. Thank you.